Welcome to NACDL's webinar, Unknown Unknowns, How to Expose the Government's Evidence Laundering. My name is Jumana Musa. I'm the director of NACDL's Fourth Amendment Center. This webinar today is going to explore the practice that's known as parallel construction. Right now, when the accused stands before a judge or a jury and is thinking about the case against them, one of the most critical components in defending themselves is understanding what evidence the government has against them and where that evidence came from. It is the starting place in terms of how to plan a defense, what pieces might be exculpatory, and what someone may argue when they're standing and facing the loss of their liberty. The government, however, doesn't always come forth with that information. What defense lawyers have found over time is that oftentimes the government will find some information in a way that may not comport with Fourth Amendment standards, find a way to then launder that evidence through other mechanisms, and then arrest the person and prosecute them. This obviously puts the defense at a disadvantage. It is quite possibly and likely unconstitutional and is something that more people need to be aware of. So we put together this webinar with a couple of experts so you can explore both how this happens, how to recognize it, and how to defend against it. Our two experts that we have here today are Sarah St. Vincent, who is a researcher and advocate on national security, surveillance, and domestic law enforcement with the U.S. program at Human Rights Watch. She is the principal researcher and author behind a report entitled Dark Side, Secret Origins of Evidence in U.S. Criminal Cases, which is part of your materials. She did a very broad survey looking into this issue, the different ways in which it comes up, and continues to look for cases. So if any of you watching have any cases where you think this may have happened, you can reach out to her later. Before joining Human Rights Watch, she was also working as a legal fellow on international human rights and surveillance, as well as working on the human rights of women in the European Union through an organization in the UK. She has her JD from the University of Michigan, and she's a member of the New York Bar. To her left is Brian Pori, who's been a practicing criminal defense lawyer for 29 years. He's served as the Assistant Federal Public Defender in the District of New Mexico, most recently, which is what he does now, which is where he started to uncover this practice and find it coming up in his cases. He has also served in private practice as an Assistant Public Defender in Oakland, California, and Albuquerque, New Mexico as well. He is a graduate from Claremont McKenna College. He served a couple of years in the Peace Corps in Thailand, as well as earning his Juris Doctorate from Yale University Law School. So please join me in, well, I guess you can't join me in welcoming them, but we look forward to a really informative presentation. You will be able to ask questions at the end by emailing me at jmusa@nacdl.org. Thank you.
Okay, hi everyone. Thank you so much for joining us to talk about parallel construction, and thank you to the National Association of Criminal Defense Lawyers for hosting this talk on what I think is one of the most serious but least reported and least understood civil rights violations out there. So thank you very much, and please do feel free to send your questions to Jumana. I'm Sarah St. Vincent, as she mentioned. I'm a researcher on U.S. surveillance and law enforcement at Human Rights Watch. And I'm going to get us started by talking about the findings from our report and the phenomenon of parallel construction in general, some legal tactics that the government might use to try to defend it and prevent its discovery, as well as some arguments that defense attorneys can make in pushing back. And then Brian Pori is going to join us to talk about identifying this in practice and litigating some specific cases. So let's just make sure, great, the slideshow works. So what is parallel construction? It's actually a phenomenon that in a way can be a little bit difficult to draw parameters around. But for the purposes of the report that we did, which I'm going to talk about in a moment, I defined it as measures that are taken by a government agency of some kind, usually law enforcement, with the intent of concealing the true origins of evidence by deliberately creating some other story for how the government found the information or the evidence in the first place. So the government goes, they engage in tactic A, but they don't want the defense or the judge to find out about tactic A, so they go back and rediscover the same information, or basically restart the investigation by doing tactic B. And I'm going to unpack that, so if you're confused, don't worry. The first thing I want to say, though, is we, Human Rights Watch, put out a very detailed investigative report on this in January of this year called Dark Side, Secret Origins of Evidence in U.S. Criminal Cases. There is a lot in here that I'm not going to have time to delve into today, all kinds of tips and citations to motions, various arguments you can make, more background, the history of this practice. So please do refer to our report for more information. And I do want to highlight for everyone, not everybody realizes this, but the cover is actually a souvenir medallion that was used within the DEA Special Operations Division, which we're going to talk about. And that's actually an image of Darth Vader on the coin that we took a picture of. So somebody in the DEA thinks they're Darth Vader, which is really perhaps all you need to know about this practice at the end of the day. Also, Reuters has done extensive reporting on this. There was a series of articles, starting with one in August of 2013 by a pair of reporters, that actually really first brought this to public attention, so I would refer you to that as well. There's also a very large set of DEA training documents that the organization Muckrock was able to get. A journalist did a Freedom of Information Act request. There are hundreds of pages of these documents, and so, for example, if you had a judge or a prosecutor come to you and say, this is just speculative, you have no evidence that this practice happens, those documents show quite clearly that it does, and that, for example, the Drug Enforcement Administration knows it does. So what are some examples? Well, one that we were able to document in this report is where the government illegally used a slap-on GPS tracking device on a suspect's rental car. That's now unconstitutional everywhere unless you have a warrant, but in Arizona at the time it was illegal under state law. The DEA then asked basically Arizona state police to do a traffic stop on this car to find a reason to pull it over and then develop probable cause to do a search. And so local police went and did exactly that. They pulled the car over for having an unlawful windshield attachment as well as an improper license plate of some kind. And they managed to get quote unquote consent to search the car, found cocaine, and the defendant was convicted in state court and actually sentenced to 5 years in prison. While sitting in prison, the defendant was re-prosecuted in federal court along with this bigger ring of which he was alleged to be a part. And in that federal case, it came out that the government had used this unlawful GPS tracking device. And so what you have here is the government, at least at first, using this pretextual traffic stop to avoid disclosing that it did something that was illegal. And therefore, like, avoiding the ability for defense attorneys to make a fruit of the poisonous tree argument. That case is called Wakil. It's discussed pretty extensively in our report. A second alleged example, which is actually from my colleague Brian's jurisdiction, is where, this is according to the defense, but there was a DEA agent who boarded a Greyhound bus during a layover in Albuquerque while passengers were off the bus. The agent then boarded the bus while everybody but the driver was off, and the agent was even alone there for some time. And the defense alleges secretly searched passengers' bags. When the passengers reboarded, the DEA basically made a beeline for one person and started asking for consent to search his bag, and lo and behold, they found, I think it was meth. The reason this came to light is that the defense obtained the surveillance videos from the Greyhound station, and so was able to say, well, we think that that second search was actually being used, the consent search was being used to cover for this earlier, they said, unlawful search. Unfortunately, the judge didn't accept that that earlier search had actually happened because the video cameras couldn't see inside the bus. But this is the kind of thing we're talking about, where the government goes and does something that it knows is perhaps legally questionable at best, or is some investigative source or method it doesn't want to reveal at first. And so then it goes and does something else to avoid having to explain what it really did at the beginning. So what are the problems with this? Well, the prosecution might tell you nothing, although I will tell you I think that there are people in government who are uncomfortable with this. When we were researching this report, we didn't find very many valiant defenders of this practice. But some basic problems and things that you can raise, for example, in motions, if you're making a policy kind of argument, is that first, this it may shield unlawful conduct. As we were just discussing, the government may be doing things that are illegal or unconstitutional, and then essentially covering them up. It also prevents defense attorneys from then making a fruit of the poisonous tree argument. You can't make that argument if you don't know what happened in the first place. Secondly, and this is something I really want to highlight because I think it's not stressed enough, it can lead to coercion of consent to search. If I'm local law enforcement and I've been asked by the DEA or Homeland Security or ICE to find a reason to pull somebody over and then develop probable cause to do a search, I would submit that the odds that the officer is going to walk away without getting consent to search seem pretty slim, perhaps. And so I do think there's a risk that people who are being subjected to parallel construction could be pressured into giving consent in a way that's actually coercive. Thirdly, there's a risk of perjury by officers at trial, and a couple of judges have started to highlight this in their opinions, where, again, if you're the officer who's been asked to do something pretextual in order not to reveal that you got a tip from some other source, there's a risk of them not telling the whole truth when you get to the trial stage or in affidavits, things like that. It also creates Brady problems. If you're the defense attorney, You can't be pushing the government to give you more Brady materials from some investigative source if you don't know that source existed. So if I don't know that the government has some gigantic phone records program, I can't actually go and really ask them to dig for potential exculpatory material from that program because I don't know it exists. It also creates potential inequalities in the justice system. Anecdotally, we sort of found in our report that if you're a defendant with a savvy defense attorney who knows about this practice and is really willing to push and make the motions, say to the government, what did you do, say to the judge, please get the prosecution to go check with the intelligence agencies or whatever the case might be. If you have an attorney who knows about this and is willing to push hard, you may get your case dismissed, or you may get a more favorable plea offer. Whereas if you're a defendant whose attorney is not as clued in, you don't have those advantages, and so it creates these inequalities in the justice system. And lastly, this is something that has been raised with me. I haven't seen it ventilated in a motion, but it's worth thinking about, is ineffective assistance of counsel under the Sixth Amendment. If you're an attorney and you don't know fundamentally where the evidence against your defendant came from, can you really provide effective assistance? Can you challenge these things effectively? So an argument that might be worth thinking about. So what could the government potentially be hiding? Well, something I want to really stress is potentially anything. I think because of the original Reuters coverage, which focused on the use of DEA tips to hide phone records programs, information they might have been getting from the NSA, other things that are really intelligence focused, we forget that parallel construction could be used to hide just an ordinary old Title III wiretap warrant that the government just doesn't want to reveal yet for whatever reason. It could be used to hide a human source. It could be used to hide something from a foreign government, a foreign intelligence agency. It could be used to conceal just about anything. And so, for example, when you're making motions, you might not just want to focus on the possibility that something came from the US intelligence agencies. But if we're going to talk about intelligence surveillance, which I think we should, there are a couple of things to think about, because again, I think that defense attorneys tend to focus on these phone records programs because that's what was first revealed as part of these programs, and that's what's often associated with this secretive part of the DEA that we're going to talk about in a moment. And the thing I really want to highlight is something called Executive Order 12333, which I'm going to get to in a moment because it's sort of the biggest and shadowiest of these authorities. I think it's the most poorly understood, but there are others. One I'm not really going to talk about very much is Section 702 of the Foreign Intelligence Surveillance Act. Section 702 is a provision that underpins some very large warrantless government surveillance programs that lead to data that can then be warrantlessly searched. It has been very well described in other places, and so I would refer you to those. You can find a lot of information on the web. I want to talk about some things that are where it's harder to find the information, but where I think those things might actually be more likely to be leading to tips that lead to an investigation. So let's talk about 12333. 12333, as I said, it's an executive order. It's not a law. It was issued by President Reagan in 1981, amended most recently under George W. Bush in 2008. So if you're looking at it, make sure you're looking at the updated version. It governs basically everything the intelligence community does. The intelligence community is 17 different intelligence agencies, ranging from the FBI and the DEA to the National Security Agency, the CIA, and a bunch of others, DHS. 12333 basically governs most of what they do, including surveillance. And we know from the Snowden documents, those documents that were leaked by Edward Snowden back in 2013, that 12333 is the legal underpinning for most of what the NSA does. And so some things that have been revealed in the press include things like the NSA vacuuming up billions of text messages daily, billions of location updates daily from cell phones around the world. So when we talk about 12333, we're talking about these big programs, lots of data, potentially huge source of information to the government, and nobody knows very much about it. The government thinks that if you've been surveilled under 12333, it does not need to give you notice. They've said this to the New York Times. I think it's come out in a couple of places since then. And so defendants are not going to be getting notice of this from the prosecution. So it's really subject to very little, if any, judicial oversight. Congress has also not been holding hearings on 12333, so it's subject to little congressional oversight as well. Basically, the executive branch is doing potentially enormous things in the dark with very little outside transparency. One thing I really want to highlight that I think everyone should read, there was a State Department whistleblower named John Napier-Ty who wrote an op-ed in the Washington Post in 2014 that I think has not been looked at sufficiently, where he basically points out that there are several other authorities that the intelligence agencies have that don't allow them to just scoop up all the audio of US people, the phone calls of people in the US, domestic phone calls. And he basically says 12333 contains no prohibition on that, which I think we should all take as code for. 12333 could be used as the basis for a lot of domestic spying on a lot of people for whom there's no probable cause to believe they've done anything wrong. And so if you have an investigation and you just don't understand how it started, you might not necessarily want to look at some of these programs that have been more reported. You might want to look at this bigger, scarier 12333. Some motions to check out. Unfortunately, none of these have led to disclosures in these cases, but I do think they represent some good models for arguments that you could make. I'm not going to read these off. I will say that in O'Shaughnessy, which stemmed out of the Malheur Wildlife Refuge occupation in Oregon, if people remember that from a couple years back, a right-wing group took over this wildlife refuge and occupied it for about 40 days, as I recall. It was prosecuted in part as a domestic terrorism investigation, and so one of the attorneys in the case said, well, you're calling this terrorism. Tell me, that sounds intelligence-y. Tell me, government, if you got data under 12333. And as I'm going to talk about in a moment, the government gave a kind of non-answer answer, but they did get the judge to tell the prosecution to go ask, or they basically got the prosecution to agree to go ask the intelligence agencies what they had done. Prosecution came back and said, well, nothing, but at least that's a sign that you can potentially get a judge to direct the prosecution, or at least get the prosecution to agree to go do something to check and see what was done, rather than maintaining potentially a state of kind of willful ignorance. So let's leave aside 12333, although again, I think it's something we should all be thinking about, and talk about those phone records programs, because they were they're a key part of this. And one reason is that when we talk about the DEA Special Operations Division, which we know has been involved in parallel construction, the Special Operations Division historically has been associated with access to phone records, potentially gathered by the NSA. There are a couple of phone records, there are a couple of laws that authorize the collection of phone records of people in the US on a very large basis. The most famous of these, Section 702 of the, Sections 215 of the USA Patriot Act, if you remember back when the Snowden leaks first happened, Snowden revealed that the NSA was getting records of all US domestic calls from Verizon. So a huge volume of data, potentially very revealing of people's social circles, their professional circles, their private lives. The government is now not allowed to get all of that en masse, but what they can do is get it through court orders. And so we know they got 151 million records of US calls in 2016. That number jumped to 534 million phone records last year, as disclosed by the intelligence agencies. I'm not aware of any defendant getting notice of having been surveilled in this way, of having their data collected under 215, or an associate's data collected under 215. So this may be something to think about asking about. There is a drug prosecution equivalent of 215 that remains unchanged and that we really don't know much about. I don't think anyone has really investigated whether that could be used for bulk collection of the kind that Snowden revealed, just different legal authority. There have also been some really large DEA phone records programs. One of those has now ostensibly ended. They say they've stopped it, and that was where the DEA was collecting records of all calls between the US and 116 other countries. So basically almost all US international communications. They say they've stopped that. What they haven't said they've stopped is something called the Hemisphere Program, which came out again through Freedom of Information requests as well as litigation. And that's where the DEA gets access to a large but unknown volume of AT&T call records. So again, this could be a very large phone records program. And phone records are something that, it sounds simple, but first we don't know what that includes. Does it include location data? It at least includes probably who's calling whom, when, and for how long. And that stuff can be data mined in a way that is potentially very revealing about what people do with their lives. So while we're on the subject of phone records, let's talk about the DEA Special Operations Division. The SOD, as we document in our report, again, dark side, Human Rights Watch, facilitates intelligence sharing between the intelligence agencies and law enforcement. And so it's best known, I think, for doing what's called a tip and lead system. The DEA SOD gives a tip to local law enforcement or other federal law enforcement. It can be as simple as, look for a white car at this intersection at this time, or look for people crossing the border who are using X farm equipment. Things that can be kind of in a way both specific and vague. And what that does is it prevents the people on the receiving end from really knowing where that tip came from. You're creating in a way like a wall, right? between the intelligence agencies that know about the sensitive programs and the law enforcement on the ground who are actually going to be carrying out the investigation. We know the DEA SOD, it's a multi-agency body. So it includes the DEA, as far as we know, the NSA, National Security Agency, the CIA, I believe the FBI. It also includes foreign partners. I believe Britain and Canada. We documented this in our report. The NYPD, we were told, and possibly others as well. So I want to stress again that the DEA SOD, while commonly associated with parallel construction, is not the only body that's involved in this, but it is one of the best known, perhaps one of the most involved, and is worth understanding as well as we can. Moving off of phone records to national security letters, again, this is probably not as common, but this is done, and this is basically an authority the FBI can use that is not a court order, it is not a warrant, it's basically a letter from the FBI saying, give us information. And Human Rights Watch got this slide through a Freedom of Information request. There's nothing on here we didn't know before, but it lays out very starkly just the scale of information, all the kinds of information the government can get without a warrant, without a subpoena, through a national security letter. And that includes information from basically anyone involved in financial transactions, banks, credit card companies, other like financial reporting institutions, things of that nature, travel agencies, car dealerships, casinos, jewelers, pretty much anyone who has anything to do with significant amounts of money, realtors. So national security letters, again, we think of this as being associated with counterterrorism, and at least in large part it probably is, but it could potentially be involved in other types of investigations as well. And the recipients of these letters are usually subject to gag orders that prevent them from disclosing that the letters were received. And then lastly, I want to mention intelligence sharing arrangements because I think this is crucially important, but again, poorly understood. There is, as was confirmed during a Senate hearing not too long ago, there is nothing to stop the US from receiving information from another country that it couldn't have lawfully collected itself. They can't ask for it. It's like the NSA can't ask Britain to go intercept something that the NSA wouldn't be allowed in the Constitution to intercept itself, but they can sit back and receive it. And we know the US has a very significant intelligence sharing relationship with what are known as the Five Eyes countries, so the others are the UK, Australia, Canada, and New Zealand. We also know, thanks to the Snowden documents, there's an intelligence sharing agreement with Israel. But the WikiLeaks documents and some other sources point to a lot of law enforcement information sharing, for example, between the US and Mexico and other countries that are involved in US counter-narcotic efforts. So intelligence sharing arrangements are, again, something that's really worth being familiar with the idea of and thinking about. So this is one of the few victories of sorts that we were able to document in our report. In an Eastern District of Virginia case called Collins, Collins involved the hacktivist, so-called hacktivist group Anonymous, which staged what they described as basically a civil disobedience campaign against various banks a couple of years ago, where they did what are called distributed denial of service attacks, basically making it impossible for people to get to the bank's websites. They were charged with federal offenses, and it came out that law enforcement might have had secret agents in certain chat rooms that Anonymous was using, and that also the government may have gotten some information from Britain. It came out in the Snowden documents that UK intelligence had been investigating Anonymous around the same time. And so the defense basically brought this to the judge and said, you know, we have reason to think that these investigative methods were involved in this case and not disclosed. And the prosecution was saying, well, we don't have any information to that effect. We don't see why we should have to go ask. And the defense pointed out that, look, the intelligence agencies all have these liaisons with the Justice Department. It shouldn't be that hard for the prosecution to go ask. And the judge turned around and said, yeah, why can't you, prosecution, go ask the intelligence agencies what, if anything, they did in this case? Why is that so hard? I've since seen this cited in some other motions. We've been trying to bring it to people's attention. It's an example you can cite in support of the idea that the prosecution should, it's not unreasonable to ask the prosecution to go ask the rest of the government what it did. I'm not going to read these off, but there's some other motions you can check out. I want to highlight the second one, Hasbajrami, because in that case, the government gave notice that the defendant had been surveilled under what's sometimes called regular FISA, the Foreign Intelligence Surveillance Act, what's called a FISA order. A FISA order basically requires probable cause to believe that someone is a foreign agent, an agent of a foreign power. So the defendant had gotten disclosure of that. What the government didn't disclose until, I believe, definitely after the plea agreement, and I think after sentencing, was that the government had also surveilled this person through the very controversial FISA Section 702 program, the one I said earlier that I wasn't going to talk about, but again, really massive U.S. surveillance under his warrantless authority. And the judge allowed the defendant to withdraw his guilty plea. He basically said it was misleading for the government not to mention it had done this potentially constitutionally questionable thing before the defendant agreed to plead guilty. And so again, this could support the idea that the government has an obligation to defendants to disclose these things, especially where they might be able to challenge them. So how is parallel construction actually carried out? The best known method is traffic stops, and I know that Brian is going to talk about that in greater depth in a moment. But again, I want us to think about looking beyond the DEA. The Drug Enforcement Administration is not the only agency that can request a pretextual traffic stop. That is, again, getting local law enforcement to find a reason to pull somebody over and search their car, potentially for drugs or firearms, and then pretend that the case started that way. We identified requests by searching case records that came from the FBI, ICE, and the Bureau of Alcohol, Tobacco, and Firearms to ask local law enforcement to do these pretextual stops. The IRS may also do these things. Reuters uncovered an internal document that I believe suggested this a couple of years ago. So why does the government think it can do this? Well, one is the Wren decision, which of course says that it doesn't matter what the officer's subjective reason is for pulling somebody over in a traffic stop. It doesn't matter if they got a tip from the government, is how the government is maybe interpreting Wren. What matters is whether the traffic violation occurred. And that's why I think you see this almost epidemic of cases of people being pulled over for broken taillight, for an improper lane change, for whatever. And then the government discovers kilos of drugs or a firearm. It's because, in the government's view, as long as that traffic violation actually happened, then everything that flowed from it is constitutionally okay. I think some judges actually are expressing some discomfort with this. And so I've given a case there that you can look to. Another is exceptions to the fruit of the poisonous tree doctrine. The government seems to be deciding for itself that it has an independent source for something, so it doesn't need to worry about the fruit of the poisonous tree rule, or that something would have been inevitably discovered. The problem, of course, is that it's not the government itself that's supposed to decide that, it's the judge, and the defense is supposed to be able to make representations about that. But from what we were able to discern, the government seems to be potentially deciding for itself that it has an independent source for something, and then just not telling the defense what was done in the first place. And then lastly, in many, if not most jurisdictions, there's a doctrine called collective knowledge. It can be vertical, which is to say between agencies, or it can be horizontal within an agency. Supposedly, this comes from a US Supreme Court decision in a case called Hensley, which dealt with the idea that you can put up a wanted poster, and that wanted poster gives law enforcement probable cause, or at least reasonable suspicion for a Terry stop, to investigate somebody. The problem is that the government is then taking this to mean that an agency like the DEA can give a very vague tip to local law enforcement, and as long as the DEA had probable cause, then local law enforcement had probable cause as well. And so this means that even if the traffic stop was actually not valid, even if there was no violation, then local law enforcement gets to say, well, we had probable cause of an offense, or we at least had reasonable suspicion because the DEA did, or because the FBI did. And one problem this raises is sometimes the federal government doesn't actually tell local law enforcement anything. They just say, find a reason to pull over this car. They don't say what they're supposed to look for. They don't say why. And so really you have no transmission of knowledge. You just have someone who's been asked to do a stop and doesn't even know what they're looking for. They just know they're supposed to look for something. Raising, I think, some pretty clear risks of coercion and excess. Some other potential methods, subpoenas for call records are honestly, I suspect, probably just as common as traffic stops, if not more so. It's very easy for the government to go get call records or subscriber information and then say the case started that way. They can also, I've characterized this as publicly available information, they can say the investigation started with a Facebook post or a Twitter account. And so, for example, we've seen at least one case investigating someone who supposedly provided material support to ISIS, I believe, where the FBI's, the affidavits in the case start with, well, we found this Twitter feed. And then, of course, the question that comes is, well, of all the Twitter feeds in the world, you found that one of this person sitting in the Southern District of Ohio. Like, how did that come to your attention? What were you really doing? But pointing to people's social media posts or their public internet activity might be one way of carrying out parallel construction. Consent searches, again, like, the government can go do whatever it's going to do in the background and then try to get consent to a search of a car, a bag, someone's person. once again, I want to raise this idea that that consent might not be valid because it's very possible that law enforcement was not going to take no for an answer. And indeed, we see records of traffic stops where law enforcement tells somebody they're free to go and then says, oh, hey, can I ask you a few more questions? And so they'll keep kind of prolonging the stop in a way that looks consensual, but where it's pretty clear that the officer is not going to go away until the defendant gives them something. Human informants. We found a case in the Western District of Texas where the government, the defense says this was to cover up potentially some intelligence surveillance, but sent a human informant basically to do a controlled buy of synthetic marijuana in somebody's smoke shop. So it could be that the government just basically uses an undercover officer or some other informant to carry out parallel construction. SIPA is the Classified Information Procedures Act, and we had people tell us for our report that SIPA is this very powerful, very misunderstood statute that could allow the prosecution to basically sanitize information such that the defense doesn't really know what went on. We don't know much more aside from that. I think it's really worth following up on and looking into, but just keep that possibility in mind. I won't deal with FISA here, but just know that, again, basically, it's always possible that some secretive intelligence authority is being used to cover up some other secretive intelligence authority that the government is even more worried about hiding. And we've seen some motions that have tried to argue that. So I'm just about to wrap up here, I think. So what are clues? How do you know that a case might involve parallel construction? Well, the first is it's not obvious how the case actually started. You know, how did they find that Twitter feed? Why did they pull over that car? Why was law enforcement sitting on that particular road at that particular time? You know, why go into that smoke shop to try to buy synthetic marijuana? Another might be, and we've seen this in at least one place, an indictment lists a bunch of defendants, and then talks about all their all the offenses with which they're being charged, which they're being indicted. And somebody's lumped in with those other people, but the connection between them is not actually clear. No one explains, whether they were in telephone communication with somebody or why is this person being lumped in with these others. Sometimes you'll see government documents that say, well, the government had a confidential source. They got information from a tip. And the concern is that the government may say confidential source in a way that makes it sound like a human being, like an anonymous human tipster, when actually it might have been, say, an NSA program. Or they don't explain what the nature of the tip is, or the coincidence just seems too lucky. Like, really, of all the cars you could have pulled over, you pulled over the one that had 40 pounds of marijuana. I think there's something inherently worth questioning about that. Briefly, I'm going to go into when the defense tries to find out whether this was done, how does the prosecution fight back? So, the first and most common thing they often seem to say is, well, the defense is just speculating. The defense has no evidence that there was any surveillance in this case. The defense has no evidence that anything happened aside from what we say happened. And the answer is, well, of course not. That's the whole point of a cover-up, is that you're not supposed to know that there was a cover-up. You're not supposed to know what they did, and you're not supposed to know that they're keeping it secret. And so the prosecution, one sign of this prosecution will avoid giving a definitive yes or no. So if the defense says, there was intelligence surveillance involved, prosecution will say something like, we don't have any information to that effect, or that's just speculation. But they won't go back and check, nor will they give you an affirmative, an affirmation or a denial. What you can do as the defense potentially is try highlighting what circumstances make your case special, what helped to raise it above that, idea that it's just speculation. So again, in the Collins case, they were, in some senses, lucky. They were able to point to these Snowden documents that said Britain was investigating Anonymous. And I think they had some other suspicious transcripts from the chat rooms. So is there something about your case that makes it seem like, look, common sense or otherwise, it just looks like something else might be going on here? And again, the intelligence agencies have liaisons with the Department of Justice. How hard can it be for prosecutors to go check? And just because they do it in your case doesn't mean they have to go do it in every case. Judges can set some sensible rules. The prosecution will sometimes argue, well, we don't have anything else that's discoverable. We don't have anything else that's relevant. We don't have anything else that would be admissible. Which doesn't necessarily mean that they don't have anything else. It means they're deciding for themselves potentially what's discoverable or admissible. The defense argued in a case called Daoud in Illinois, well, why should prosecutors get to be the ones who decide that and be the gatekeepers? It should really be the judge, who's in that role of deciding what's discoverable. But this is an argument that you may see. For Brady purposes, we've seen this argument several times that intelligence agencies aren't part of the prosecution team. So under Brady, the government is supposed to go in and get any exculpatory evidence in its possession. Prosecution will sometimes come back and say, well, the NSA isn't part of the prosecution team. And I think the answer to that is sometimes to look back at Brady itself and some of the subsequent US Supreme Court cases that make it pretty clear that it's really any evidence that the government has. It doesn't really matter who it belongs to. So they'll say, for example, they have, again, no reason to believe information came from the NSA or some other intelligence agency. But again, it's not that hard for them to go check. So lastly, the overarching point I want to make, especially for anybody who's watching this who's not a defense lawyer and won't be using this in their practice, is if parallel construction is legal, does the Bill of Rights still have any meaning? If the government can go and violate your rights in the dark, nobody ever finds out, and there are never any consequences, what meaning do those rights still have? Doesn't it just turn them into words on paper? You could potentially have a monitoring program that targets people based on their race or based on protected First Amendment activities, or other really egregious activities like massive illegal surveillance programs, or at least arguably illegal surveillance programs, and we might never know. And that's simply not how US democracy is supposed to function. And it deprives defendants of getting a remedy for abuses. It deprives everyone everywhere, potentially, of getting a remedy for abuses of their rights. So I'm going to conclude there, and I think I'm going to hand this back off to Jimena. Or no, straight to Brian. We'll go straight to Brian, who's going to talk about some parallel construction cases. So thank you for listening.
Thank you, Sarah. Before I get started, this is a kind of a different venue for me. I'm used to speaking live to human beings, but it's still the same ground rules, namely that when you're preaching to the choir, it's best to invite them to sing along, and so too when you're presenting to lawyers, it's best to invite participation so that the collaborative sum of our efforts will be more than our aggregate individual parts. So I'm going to repeat the email address, and I hope I get it right, jmusa@nacdl.org. If you have had cases like this, if you have thoughts on this, if you're just suffering from that lawyer disease, to say something or have the last word, that I invite you to there'll be time for questions at the end, probably lots of time, so we invite as much participation as possible. And what we're talking about is a world where law enforcement officers know what they are looking for before they even start to look for it. This is kind of creepy. Then when they find what they're looking for, they need to create a different narrative as to how they found what they were looking for. And the result of that is that it compels law enforcement officers to obscure the original source of information and deliberately create alternative explanations. Those of you who've ever had a money laundering case will see it for what it is. We call it evidence laundering. Some people call it intelligence laundering, working backwards to the source in a way that encourages law enforcement officers to willfully and deliberately lie. And I take great pride when people ask me what I do for a living. Sometimes I'll mess with them and I say that I'm a law enforcement officer. And the truth is, I am a law enforcement officer. I enforce the 4th, the 5th, and the 6th Amendment of the United States Constitution. And with this practice, we need all hands on deck, because to the thought that the government can obtain information without a warrant, use that information, never disclose it, and send someone to prison by setting a trap for them, that's anathema to the 4th, the 5th, and the 6th Amendment. So in my presentation, I'm going to talk briefly, because I think Sarah did a really good job, about the sources of information which federal law enforcement agencies will often obtain and pass on to local law enforcement. Your materials contain a practical example from one of my cases to show how that plays out in real time. And we're going to go back to some of the clues that Sarah was talking about and point to some of the signs that you might be dealing with a parallel construction case. We're going to talk briefly about the tools that are available to you as a defense attorney to shine a light on this practice. And then we're going to conclude with a general discussion about how bad this practice can be for us and for our clients and for a rule of law, a nation that prides itself on the rule of law. Before I get into specifics, I got to do a disclaimer. I'm from a smaller jurisdiction. I practice in New Mexico, and inevitably, anytime I do a presentation or file a motion, I have law enforcement officers coming up to me. I heard you talking trash about me. I filed a motion in an ATF case, and I'm at a social distortion concert. And the ATF officer comes up, why are you talking trash about me? I'm like, I'm not talking trash about you, I'm talking trash about so-and-so. Oh, yeah, well, so-and-so. So I've never been shot at in my job. People don't shoot at me, so my job is easy compared to the average law enforcement officer. And there is nothing better than an honest and conscientious law enforcement officer who prides themselves on not creating things or obscuring things, who prides themselves on being able to tell the truth all the time. There are United States attorneys and district attorneys, like the one in the materials that I provided to you, who pride themselves on their good name and their good actions, and that when they find that they've been lied to or had someone obscure the source of information, they might just move to dismiss themselves. So when we talk about a few bad apples, we're certainly not meaning to suggest that they've spoiled the whole bunch, but I will not sing the Jackson 5 song to that same effect. So we're talking about the militarization of domestic surveillance. And Sarah did a good job of talking about the sources of information. In my experience, most of them are intercepted telephone calls, because apparently, and I wonder how many on the Supreme Court who've never been called upon to pass on this practice would sign off on the fact that if you call someone overseas, you have no reasonable expectation of privacy in that call. They don't need to get a warrant to listen in on that call. The folks in that round building that Sheriff told you could just sit there and listen away and take all that information down and use all of that information against you and never once tell you they did it. So the telephone calls are a big one. I think other lesser programs are emails, bulk data collection, all of that. And when you think about the law is simply not keeping pace with the technology. You know, when the Supreme Court, when we're talking about a Supreme Court that was sitting when I was born, which was a long time ago, and in a case like Katz, they're trying to get their arms around, well, the guy did use a payphone, and if you ask some people now, what's a payphone? They're not going to know. And yet this concept of like reasonable expectation of privacy has not kept pace with the fact that everything in my life is inside this phone. Every call that I make, every place that I go on, every website that I surf on, it's all in there. And a government that can just gather up those records and take a look at them and profile me and figure out who I am, I think I'd like to have a little more say in that than just calling it the bulk data collection. And in my experience, there are two primary organizations that have been doing this for years, long before 9/11, long before the rationale of a world of terror came into being. And those two organizations are first the DEA and then second Homeland Security. And again, disclaimer, not all bad apples. The DEA has been gathering up international telephone calls since 1992. Before there was the NSA, before there was 9/11, there was the DEA phone surveillance program known as USTO, which tracked billions of Americans' international phone calls. It was for a good end in the sense that the DEA was trying to find Americans communicating with drug cartels in Colombia and Mexico and around the world. But the DEA has tracked billions with a B, of Americans' telephone calls since 1992. And in my practice, the DEA takes that information and gives it to either a fellow DEA agent in New Mexico, or more commonly, a task force officer associated with the DEA. And the other one is, of course, the national security agencies, scooping up the international communications and metadata and all of that. And I wanted to pause here and say, these are the things that we know about. These are the things that we are aware of. The tragedy and the scariest part of this whole presentation is right now they're doing things that we have no idea they're doing. And it's going to take conscientious journalists and people like Sarah at the Human Rights Watch, it's going to take them years from today before us, podunk law enforcement officers know what's going on and try to take steps to curtail it, if not to stop it altogether. But that's the kind of sources of information that they use. And so I give you an example in the materials that we provided of a case that I have. And it's in describing that case that I'm also going to tell you a few of the clues that you need to look for. The facts of the case are relatively simple. My client, Claudia, was an undocumented immigrant living for many years in Phoenix, Arizona, and she was taking a road trip to visit her cousin in Albuquerque. And as she was driving to Albuquerque, just outside the city limits, she was pulled over by a sheriff's officer. And the sheriff's officer pulled her over for making an illegal lane change. And you know, Sarah touched on this, and I think those of you who are lucky enough to remember the movie Casablanca, the standard is a simple one. Of all the gin joints in all the world, she just happened to walk into mine. So of all the cars traveling on Interstate 40 that day, close to Albuquerque, and of all the gin joints, you see, the people who make these stops are not traditional traffic officers. Many state police, highway patrol organizations, they have two different levels of law enforcement officers. One are patrol, people who are regularly on patrol, citing people for speeding or unsafe lane change and the like. But there are also these specialized units. In New Mexico, our state police calls them the criminal interdiction unit. These are units that are devoted to the enforcement of the criminal law and interdicting things like drugs and guns. And inevitably, the people who are involved in these parallel construction sites are not patrol officers, they're the specialized unit. And so much is true for this case. When I got this case for Claudia, I thought to myself, why is a sheriff's officer pulling someone over on an interstate highway? He should be in the county. And then the other thing is, like, how many people get pulled over for an unsafe lane change? Now, you know, we talk about a lot of these stops in terms of pretextual stops, that the stop is a pretext. Well, those of you who have practiced know the Wren case, W-H-R-E-N, where the Supreme Court said that's absolutely fine. And so I think it's important for people who are going to try to attack these stops to begin with a very basic assumption, and that is, we're not talking about pretext stops. We're talking about unjustified stops. You see, in a traffic stop, the stop must be justified at its inception. And if it's not justified at its inception, all the other information may flow in a continuous chain, unattenuated by any taint, you know, so that the taint still survives when they discover the evidence. And I think that's what we had in the case that I've given to you, an unsafe lane change. I think the easiest way for any defense attorney to begin to challenge these kinds of practices is not to concede the original justification for the stop, not to set it up in a Wren state where the stop was pretextual, because most judges will then say, well, they can do that, so sorry, guy. But to say, no, the stop, it's the prosecution's burden to show that every step along this process was lawful and justified. So I'm going to put them to their burden. I'm going to say, no, she did not make an unsafe lane change. And then that's the other thing about it. When you look at the facts of this case, the BCO, the sheriff's officer says, she pulled an unsafe lane change right in front of me, which tells me he was following her. And following her to the point that when he forced her into what he perceived to be an unsafe lane change. You know, in New Mexico, we're lucky in the sense that we have our state police are equipped with video dashboard cameras. And when the whole world is full of dashboard cameras, all us lawyers will be bagging groceries because the cameras will do all of our facts for us. But until that time, even with a dashboard camera, you will find in these parallel construction stops that law enforcement officers have to make a U-turn across the median of a heavily trafficked interstate and travel 100 miles an hour to catch up to the defendant. And then you say, well, what'd you pull him over for? Speeding. Well, come on, guy, you were going the other way. You will see, if you scratch the surface, that first of all, the people who are pulling these people over are either a criminal enforcement unit, a specialized unit, or in the case of my Bernalillo County Sheriff's officer, a task force officer assigned to the Department of Homeland Security. And in our, jurisdiction, close to the border with Mexico, we have a lot of HSI and DEA stops. And it fits that DEA is funneling information to other DEA that comes out of the Special Operations Division, the SOD of the DEA. And the HSI is funneling it to task force officers. And there's a little side note to bear in mind that I think every practitioner needs to be aware of. Homeland Security was created after 9/11. Homeland Security, in my humble opinion, is the Keystone Cops of federal law enforcement, because this is an agency that is getting enormous pressure to grow and to grow and to grow. I know how we can get tough on crime. I know how we can fix the border. 20,000 new Border Patrol agents, 50,000 new Border Patrol agents. Well, as you would expand a department rapidly, you pull in officers who might not be as well trained as you, say, an FBI agent, and you also create an inexorable pressure on that organization to keep driving their numbers. Do not forget, we're talking about a bureaucracy. We're talking about an organization that exists for its own purposes and that has to justify its existence. And so there's enormous pressure on Homeland Security to create more crime. And they will use whatever means sometimes are available to them. And I think that's very concerning. In this case, it was Homeland Security. It was a sheriff's officer with a task force assigned to Homeland Security. Well, that will give you an opportunity to start to ask some very interesting questions. The most important one, what were they doing before the stop? You know, if this guy is a task force officer assigned to Homeland Security, I'll bet you $100 there was a briefing before he went out on that highway, and they were told what to look for. In New Mexico, we have access to police reports either publicly or by a request from the court, 17C type subpoena, where you request all the other police reports you wrote that day. Or if it's the state police, they have duty logs. So they'll tell you what time you went on duty. And then you can ask for dispatches. What were you doing in the time between the time you went on duty and the time you pulled over my good friend Claudia? In some cases, we have found that by looking at those duty logs, we found that all the police were doing that day were stopping cars from California. That they had made 7 stops of other cars before they stopped the defendant in my case. And that kind of gives you a peek and gives the court a peek as to how this process can be abused. Namely, the other 7 cars that were stopped that day, they weren't charged with anything. All they had was the minor inconvenience of their travel being interrupted. But if police are going to just start pulling over cars because they have a California license plate, there's at least 7 drivers who are inconvenienced. If those drivers have kids in the car, there are at least 7 little kids who are like, Mommy, what's happening? If they have my mother in the car, son, why are you I told you not to speed. You have the police not doing a terrible thing to innocent travelers on the road, but certainly abusing their power, trying to find that needle in a haystack. So if you were to look at what the officer was doing before the stop, it will give you a very clear picture of how this could very well be a parallel construction stop. In the case that I provided to you, we have something even more telling. We have a police officer, a sheriff's officer, who stops a car and then asks the driver to exit the vehicle. Now, I don't know how many of you are familiar with New Mexico. New Mexico is a very wide open, sparsely populated place. I'm a speeder extraordinaire. I drive 100 miles an hour when I can get away with it. And so I've been pulled over all the time. Usually I'm driving a government vehicle. They think I'm a DA. They let me go. It's fantastic. But I've never been asked to step out of the car. Never. And in all of these cases, every single one, could you step out of the vehicle, please? Now, if it's a young, hoodlum, gangster, whatever, maybe, but we have Claudia. Claudia was in her car with 3 children under the age of 8. And they asked her to step out of the vehicle. When you think about that, that's kind of an outrageous request. What parent is going to feel comfortable stepping out of their vehicle away from their children on an interstate highway? But it's something in the nature of these cases where they want to get the person out of the vehicle. Why? Maybe so that when they go to run the wants and warrants, they can't hide anything? I don't know. But the person comes out of the vehicle in almost all these stops. The other thing that is telling is that other officers arrive on the scene. Again, when we have video, it's never just one cop. Now, mind you, let's work backwards. Let's start from the source of the information. You're going to be looking for a Nissan from Arizona that might contain illegal drugs or an illegal firearm. Well, now they're pulling over Nissans, and they're not traveling alone, these police officers. They're traveling up and down the highways, and when they say, I got the Nissan, it's like calling the cavalry in. You'll see 1, 2, 3 different police cars stopped at that scene. I had one case where with a dashboard camera, my client was stopped in front of another police officer. I'm like, what's that other police officer doing there? Just coincidence. Well, the more coincidences there are, the more likely you're dealing with something like parallel construction. And then what unfolded during the stop gave me, in my opinion, just irrefutable evidence that we were dealing with parallel construction, because Claudia did not have a driver's license. And she told the officer, I don't have a driver's license, or my license is expired, or whatever. That didn't bother him at all. He was not concerned at all. Like, what do you mean you don't have a driver's license? You can't be driving without a driver's license. You need a driver's license. Just didn't bother him at all. Just on to, okay, well, let me cite you for unsafe lane change. He didn't even cite her for not having a license. And then in our jurisdiction, when you complete the citation, when you hand the driver's documents back to the person, but you're still outside of the car, away from your children, the officers say, hey, can I ask you a few more questions? Everybody says yes. The 10th Circuit considers that a consensual encounter. And that's what the police are banking on, that this will become a consensual encounter. And so rather than focus on things that should have mattered, like no driver's license, the cop begins to start saying, well, do you have anything illegal in the car? She's like, no. And he says, what about a firearm? That's an odd question to ask someone. What about a firearm? Then he said, what about meth? What about... And in my experience, oftentimes, the very first thing the officer asks about is the very first thing he's going to discover in the search of the car, because it was the very first thing he was looking for before he even knew to start looking for that car. That's how you can tell that they're not as sophisticated as they would like to seem, that they're not so good at covering their tracks, and that to me, when the first thing he asked her about was the thing that he ultimately found, I knew for certainty as a practitioner that this was a parallel construction stop. But that still leaves us in the dilemma of, like, how do you bring this to light to the court? Sarah talked about the prosecution's responses. How do you know to ask for something that you're not really sure even exists? And of course, the government is certainly going to say, oh, Mr. Pori, he's king of speculation. He's just speculating. This is a total waste of your time, and he should be sanctioned. He should be ashamed of himself. But there are some tools in our arsenal that we can employ, traditional tools, to ferret out instances of parallel construction. To me, and I included one in the materials that we passed out, this is a motion to disclose a confidential informant. It's been around for a long time. It's the Roviaro case, R-O-V-A-R-I-O. And, when the cause demands it, when the confidential informant is a precipient witness or has material information that will help in an adjudication of the cause, the government can be ordered to disclose it, that the defendant's need and right to a fair trial outweighs the government need to protect the secrecy of this informant. Well, that's what we're dealing with here. It's just the informant's not a human being. The informant is a source, an intelligence tip from a federal law enforcement agency. And the other one, of course, is Brady. Brady should be as expansive as we can possibly make it. Sarah talked about the government would say, well, the NSA is not on our team. Well, he's not on your team every day, but you put him in as a pinch hitter when you gave him that tip and pulled Claudia over. So for this case, they're on the team. And again, when you explain to the court the circumstances under which these officers knew they were going to stop that car before they even saw that car. And you point out, when you saw that car, you had to catch up to it to cite it for an unsafe lane change or for speeding. Or in this case, you were following that car for God knows how long until they did something that you could pull them over for. And you can explain to the judge in fairly clear ways that the person being prosecuted is not being given complete discovery of the evidence that's going to be used against them. And then, there's a motion that I've not yet made, but I hope to one day, and that is just, we're asking for this in the defense of the Fourth Amendment. Everyone always cites the Olmstead case, where they talk about the government as a great teacher, and if the government breaks the law, then what's the point of the rule of law? If the concealment of investigative methods prevent defendants from challenging unlawfully obtained evidence used against them, that is exactly what Sarah's talking about. That is exactly, the Fourth Amendment means nothing but the words on the paper. If you began this case in an extrajudicial, unconstitutional, illegal, intercepted telephone conversation without a warrant, or sweeping up cell phone records and looking at the contents of communication without a warrant, then we as law enforcement officers have to assert our role and call the government out on those problems. I think to me, that's the area where we have the most likely, have the greatest chance of success in these kinds of cases. Because never forget, my favorite joke of all time is, what's the difference between God and a federal judge? The answer, God doesn't think he's a federal judge. But federal judges especially take great pride in the fact that, this is in my courtroom, this is how we do it, and so when you say to the judge, they're obscuring the extrajudicial source of information, that prevents you, as God's minion on earth, from assessing the constitutionality of this surveillance practice. These investigations take place in complete secrecy with no judicial oversight. And that's why I think the easiest way to present a motion, if you trust the judge, is to present it, say, I want them to disclose it to you in camera, and you tell me if I get to see it. Because that way you're saying to the judge, I don't have to see it, I don't have to know it, I just have to know that what they have followed the law, and that what they're using, it comports with the Fourth, the Fifth, and the Sixth Amendment. And I think that shows a level of trust to the court. Of course, you're not going to do that in every case, I learned in school the law is only as good as the judge who interprets it. So if you have the luxury, like we might have in a large public defender office, of choosing your battles carefully so that you pick the best battle with the best facts and the best judge, that's great. But if not, you got to dance with who you brung. To always rely on the court and to put confidence in what the court is going to do to maintain its own integrity, and that's how I view this whole process as a defense attorney. Sarah talked about ineffective assistance. I wouldn't necessarily say it that, but I'm a little bit offended. If you think you're going to try to bring some secret evidence into my case and okey-doke me and make me think, look over here, Brian, and when I should be looking over there, I'm personally offended. That's my job. So like a basketball player, don't bring this into my house. If you bring it into my house, you better be prepared for me. And, luckily, criminal defense attorneys have thick skin, so we're not afraid of being like, that's outrageous, get out of here, you owe me $1,000. Okay, fine. I'll probably end with this. It's funny that we're in Washington, D.C. today. It's a beautiful day, and it should be a dark and stormy night to talk about such practices, but with the recent election of our president, some people are talking about the deep state. I think that's what they call it, the dark state, whatever. Deep state, dark side. We may find out that, the campaign of this president did something illegal precisely because of parallel construction. That when one of his little aides called up to the Soviet Union and some FBI agent was like, what? That's for the good. But when you create a shadow world in which the parallel universe of the deep state conceals the process in which people are being investigated, incriminated, and convicted, that is the end of the rule of law as we know it. That is the end of constitutional democracy as we know it. It sounds, kind of, maybe it's hyperbole, maybe it's a bit too excessive, but the fact remains that it's clear to me that law enforcement officers are actively engaging in highly questionable, often unlawful activity that violates the Constitution that very officer is sworn to protect and defend. So in a world where so many law enforcement officers I know view the world as good versus evil, good guys, bad guys, and then they adopt a moral relativism that allows them to do evil things for the sake of the good. That's a problem for the whole world, and particularly from law enforcement officers sworn to protect and defend the Constitution. There's one other thing that I'm just looking through my notes now, and inviting questions, inviting people to comment, critique, or add to the stew. But one thing that hasn't been, that I'm aware of, and I don't know, Sarah, if you've seen this, there's this thing called the Posse Comitatus Act, which is a great name. You know, I wish I had a posse. You know, in New Mexico, you get a posse when you move there, but that's kind of cool. But anyway, the Posse Comitatus Act prevents the military from enforcing domestic law enforcement. It's come up when the National Guard goes to the border to enforce the border. They can't make arrests for people for illegally entering the United States. The Posse Comitatus Act, prevents the use of military personnel for domestic law enforcement purposes. And so I don't know if it's been successful, but it's certainly something that I think bears looking into, in addition to the motion to disclose a confidential informant and the Brady information, the motion in defense of the Fourth Amendment, the idea that what began as a tool in the war on terror is now used indiscriminately to target individuals for prosecution, to me is a rich source of potential a potential challenge. You know, I'll finish this with the story of Claudia. You know, Claudia was an undocumented immigrant, and luckily, as soon as she was arrested, I had a great magistrate judge who released her, even though she was not an undocumented immigrant. Claudia was able to be released and to go home. And then when the materials was the motion to disclose a confidential informant that I filed, I didn't even file it. I sent it to the prosecutor and said, I'm going to file this motion in advance of our evidentiary hearing before this fantastic judge. And once I filed this defendant's opposed motion to disclose any prior information in the possession of the Bernalillo County Sheriff's Office of the Department of Homeland Security, that same day, I got this motion to dismiss the indictment. And these are the types of cases where, you know, they were prosecuting Claudia for being an undocumented immigrant in possession of a firearm. That's about as bottom of the barrel as you can get in federal court. And Claudia was a good person. You know, she had no previous criminal record. She had done well while she was on pretrial release. The judge who was hearing the case was not likely to ever send Claudia to prison, but if Claudia was convicted, it is certain that she would have been deported from the United States. By that motion to dismiss, 3 U.S. citizen children still have their mother living in their home, so there was a happy ending for Claudia, and hopefully there'll be other happy endings for other people who participate in this seminar. And that's, I don't know if you have anything to add. I know we have time for questions.
Well, it's hard to add anything on top of, I just want to make sure this is on. Yeah, okay. I mean, it's hard to add anything on top of a story like that. What I do want to say is actually pick up on something that you had said, and that is, you know, my initial remarks about the Darth Vader medallion and so on aside. I mean, DEA, we all know, does a very dangerous job. I mean, all federal law enforcement does a very dangerous job that most of us could never do. And I want to say that in researching the report, it was my impression that sometimes parallel construction can be and is used to conceal things that law enforcement or the intelligence agencies should know is illegal, but that often the government thinks that whatever it's done in the background is lawful. So it's not necessarily the case that they are running around willy-nilly hiding illegal activities they know are illegal. The problem is, to extend maybe some of Brian's sports metaphors, they're basically trying to referee their own game, and they're trying to make the calls about what they think is lawful or not, and that's just not how our system works.
Yeah, and that being said, you cited the Grobstein case, and I have no hesitation in saying the DEA agent involved in the Grobstein case is a bad apple, and is a person known to push the envelope of law enforcement because of this "I'm a good guy, they're a bad guy, let's go" mentality. And oftentimes, I know in researching this presentation, there were some prosecutors who were given this case by a law enforcement officer, And they themselves were given a false narrative to explain how this investigation began, so that when they discovered the truth, they themselves were offended. You know, it's like, I can't have my officers lying to me. If I'm gonna put my credibility on the line, I need to know I can trust the officer that I'm advocating for. And so I would like to think that, you know, in a world where most people are good and where the truth will will out, that if a prosecutor is offended because this false narrative, this evidence laundering was peddled before them in the first instance, that might be another. I don't know why this case was dismissed for Claudia, but if I had to guess any reason at all, it would be because the prosecutor who dismissed the case, I wish that the world were full of all prosecutors like her. And she either decided that this case wasn't worth it, or that something offended her moral sensibility, and hers is a moral sensibility that's much better than mine, so I'm grateful to her and for her doing the right thing. And I wouldn't want anything I say to impugn her or her other law enforcement officers who have a similar moral compass.
All right, well, thank you to Sarah and Brian for outlining the path to the end of our constitutional democracy. Very uplifting afternoon. We are obviously open for questions. You can email them to me again at jmusa@nacdl.org. We actually already have a couple of questions, but I'm going to take my prerogative to ask you one first. One thing, you talked a lot about different surveillance programs and how this information may have ended up in the hands of the prosecutor, but I could be wrong. I didn't hear you speak to surveillance technologies. I know in the past things like Stingrays were very much hidden, or cell site simulators that were used to vacuum up people's cell site location information as well as the content of their calls, etc. And I also recall through one FOIA request, there was one agency who got a letter from the government saying, you can use this for lead purposes only. But if you're going to prosecute anybody, you have to find another way to this information, essentially laying out the path for them to launder the evidence through some other means. And so I was wondering if either of you could speak to the question of surveillance technologies that are being used, coming back actually from war zones to being used by local law enforcement that may be also used to launder evidence.
Yeah, thank you. You've teed up perfectly a blog post I'm hoping to put out on HW's site later this afternoon that's about the Amazon facial recognition technology that's been for sale to law enforcement that the ACLU of Northern California did some amazing reporting on and disclosed yesterday. As we say in our report, one of the dangers of parallel construction is that these new technologies, potentially very invasive and potentially threatening constitutional rights, will never actually get before a judge. So yes, Joanna is right that there have been non-disclosure agreements and other methods that, at the time, innovative technologies like Stingrays or things that had come back from the battlefield and were being deployed in the United States, often in vulnerable communities, those things were not disclosed, so the defendants could never challenge them. And we never found out from a judge whether they thought that violated the Fourth Amendment or any other constitutional rights. And I think there's a similar danger with facial recognition, other biometric technologies. I mean, there are things out there like gait recognition and gesture recognition, if you can believe it. Voice prints. I'm trying to think, gosh, what are some other things that could be out there? Artificial intelligence. So, yeah, I do think that there's a risk that, that there are going to be new technologies that raise serious constitutional questions that the government is going to decide those things are legal, but judges will never get a chance to take a bite at that apple.
And cell site simulators are probably the most dangerous new technology that we know of, that we may see. And to your point, what the cell site simulator does is it's a portable cell tower. And instead of routing a call through a fixed cell tower, the police drive in a van and park it out in front of my house, and all my calls to the chat line go through the cell site simulator, and they know Brian Pori's calling the chat line. Oh, no. But what that means is that not only can they find out the source of the call, not only can they find the location from which the call was made, but they can listen in on the content of the call without a warrant. So, and then the cell site, the people who make the cell site under the name Stingray, they have made law enforcement officers sign non-disclosure agreements so that you can't disclose that you used a Stingray. Well, to me, you can't have a law enforcement agency with a non-disclosure agreement. That would violate Brady. That would violate the Fourth Amendment. But that's what's happening. And then the other one that I think is particularly difficult, and it all goes to the sense of like, is there any privacy left anywhere in the world? Yes, there's privacy if you lock the door, close the blinds, turn off your cell phone, because as we learned from the Chinese Olympics, if the cell phone, even when it's off, take the battery out, because they can use the speaker to listen in on what's happening. The levels of surveillance in this world boggle the mind. But the two that are probably going to be presenting themselves more frequently is the cell site simulator, and the other one which concerns me is the license plate collection that I think it's the DEA is had a license plate reader program that they just read license plate, and Brian's car was over here at midnight, it was over here at 4 a.m, it was over here at work at 8:30. What was he doing between 4:30 and 8:30? I don't know. And if the purpose of this information is to put it this way, in the wrong hands, the information about an individual's private life could be used to destroy that individual, and not irrespective of any kind of criminal case. And so the answer to your question is yes, there are many technologies that are up and coming that we haven't had as much experience with, that are shrouded in secrecy deliberately, either because of non-disclosure agreements or, like you say, the agency that gives the intelligence tips said, this is for source purposes only. And then you have people in the field that are so excited by this information they can't help but reveal that they received a tip. So how we're going to deal with those, I think we leave to the future, but it is certainly something to be aware of.
All right, thanks for that. So we do have a question, I guess it's a more global question, but can parallel construction be permanently enjoined? What, if anything, would grant standing and cause a cause of action to do so? No pressure.
A permanent injunction, I don't have standing on behalf of everybody in the world. I guess you could do a motion for declaratory judgment if you're aware of the program and you want to take it. But I can't see many judges being eager to enjoin such a practice wholeheartedly, because you could see that there might be some good come out of this. If it's used to prevent an attack on the homeland, then bring it on. But if it's used to identify an individual in violation of their Fourth Amendment rights, it's probably, my parochial view is probably best litigated in the individual case.
Yeah, so as anyone who's ever delved into intelligence surveillance knows, especially when you talk about surveillance, standing can be, you basically can't establish standing unless you have notice or some other evidence that you were surveilled. Our approach in this report, when we made these recommendations, were based on the theory that if change is going to come to this practice, this practice basically stems from judicially developed doctrines. Like I outlined in my presentation, this is all based on things the Supreme Court has said, although I think many of those things are things that the government is interpreting broadly at best and poorly at worst. And so I think it's going to be up to the courts to undo a lot of this damage and to be compelling the prosecution to disclose things, compelling prosecution to go back and ask the intelligence agencies or other bodies what they did, and also potentially on Congress to outlaw it. With that said, there's a lot of information that we still don't have. For example, we know the Justice Department has a policy about when it needs to notify people that surveillance obtained under one of those controversial authorities I mentioned, Section 702 of FISA, has been used in their investigations. The Justice Department has been sitting on that policy. They've sort of described it a little, but they've never disclosed it. And they've also, as I said, told the New York Times they don't have to give anybody notification of surveillance under 12333. So I think that if people want to be tackling this and you're not representing somebody in a criminal case, the things I would do would be, one, raise awareness of it. Tell everybody you know, tell every defense attorney you know, which is why I'm here today. Two, press Congress for changes in the laws. And three, be pressing the executive branch to disclose exactly what it thinks it's allowed to do and why.
And I think you hit on, if your goal is to stop this practice, then the person who needs to achieve that goal is in the U.S. House of Representatives or in the Senate. That not enough people know that this practice goes on. Not enough people know that they're one of the 7 cars from California that was stopped that day before they found the 8th one. Not enough people know that even though they have nothing to fear because they don't break the law, this program exists and is subject to abuse and could affect them and their right to travel from state to state. So I think raising awareness, even aside from this seminar, at a cocktail party. Did you know that the law enforcement can, pretend to create a reason for a stop that's completely false in order to protect the deep state. And maybe people of all, and this is a beautiful thing about the criminal law, is we're all criminals at one point in our lives, but more important, we all believe, libertarians and civil libertarians all believe that the government is a government of limited powers. And the more we learn that the government has aggregated power to itself and exercises those powers without review, the more the spirit of 1776 burns in all of us.
All right, so we have another question, and I'm not sure if we'll have time for one more after this. But this is about a specific case, and it's how can we make a Fourth Amendment or other kind of challenge when the prosecution starts from information that was unlawfully obtained by a foreign country? So this person has a case in which they believe their client first came to the attention of the U.S. based on information obtained through surveillance and an illegal search of the client in Thailand by Thai authorities. The client is Syrian. The U.S. government obtained a 2703D order for email addresses likely obtained in the Thai search, and the rest went from there. The person's been convicted on 4 counts and sentencing is pending.
So this is very similar to the Collins case. Do you want to take this first, or do you want me to take
No,
this
I'm going to
first?
let you take it first because I'm going to think of an answer.
Yeah. So my first response is email me because give me some time to think about this, and also look at our report, and there might be tips in there about motions that you can look at. And in particular, I would direct you to the Collins case that I mentioned, that prosecution of anonymous. So my email address for the good of the order is stvincs@hrw.org. And you can, email me with any suspected parallel construction case, and I'll do my best to tell you what I can. In terms of how you discover information from a foreign government, it sounds like you have something to lift you above this level of, the prosecution being able to say, oh, this is just speculation, right? So I think I would look to the Collins motion and say, basically, I would think it would be about getting the judge to direct the prosecution to disclose what the U.S. got from those foreign authorities. Because certainly if those foreign authorities did that in a way that violates rights or was illegal under their own law, or would violate the Constitution of the U.S., I think you might have some arguments. I'm not actually a human rights expert, not a criminal law expert, so you'd want to talk to somebody else about that. But it sounds to me like you've got more than what most people have, which is evidence that something happened. And so in that sense, you're in a better position than most. So I would be taking that to the judge and basically trying to get the prosecution to disclose things. But again, please get in touch with me and I might be able to say more.
And I think that, there are certain cases, I don't have them off the top of my head, that talk about you can't torture someone in a foreign land and use the results of that tortured confession in federal court, that there's a bar set by the Fourth Amendment, the Fifth Amendment, the Sixth, the Eighth Amendment, that even when you're using sources of information from other countries, still need to meet that bar. And so the idea that, again, I think there's a motion out there waiting to be written that says the government as the omnipresent teacher, this violates its role as the omnipresent teacher, and the Olmstead motion in defense of the Fourth Amendment. Because there are certain practices. The other thing is you see growing these evolving standards of decency which inform the interpretation, particularly the Eighth Amendment. That what was acceptable at the time of the founding is certainly not acceptable now, like banishing people or torturing people. And so when you look at the Eighth Amendment jurisprudence, the court looks to other jurisdictions, other places around the world. Originalists hate that, but most people say, yeah, if we're in league with China and Iran and Saudi Arabia when it comes to the death penalty, maybe that needs to inform our considerations, these evolving standards. That's just kind of off the top of my head, that's a tough case that you got.
I could add that as controversial as WikiLeaks is, there's a lot of information. You can go into the WikiLeaks documents, they're searchable, and especially if you look at things like emails that were leaked from a malware company called Hacking Team, which basically sells hacking surveillance software to governments, and also the cables that Chelsea Manning leaked, you can document an intelligence sharing relationship between the US and Thailand potentially, or you can at least establish that there's a close law enforcement relationship there. You can also be looking at State Department grants, like have there been joint prosecutions, has the FBI announced anything? So I think that you could potentially look at some of those sources that have been leaked, but also some things the government says publicly to establish that the U.S. seems to have some sort of intelligence sharing relationship with Thailand.
And there's also the criminal cases that say if you involve a non-state actor to do the state's bidding, then the Fourth Amendment applies to the non-state actor. That's say if you ask the FedEx guy to open the package because you can't. And I think that same sort of reasoning would apply if you have any evidence that this information was collected at the request of the United States government, then I think you certainly have a Fourth Amendment issue.
Okay, so we have one last question and a few minutes to answer it. And this is more sort of about a more global question, but how can a person best assess the relationship between federal agencies that have access to surveillance program and their local law enforcement in the region? I know you talked about sort of the task force representative or this and that. Can you lay out a little more of what does that structure look like, and how do people either recognize or find out what kind of relationships are?
For us, the task force officer is a natural connection. And in the example that I gave, the sheriff's deputy is working with the Department of Homeland Security as a task force officer. So it's easy to say, oh, I have this from NSA, I give it to HSI, I give it to BCSO, and you see it just a straight line through there. In more rural jurisdictions that don't have task force officers and things like that, I think that might be a little bit more problematic, but we don't have to know for certain that parallel construction is occurring. We just have to ask the question. There's nothing, if we have enough facts to have a good faith basis to ask the question, then we're entitled to ask the question. So we don't need to prove it like a mathematical certainty. We just need to take the facts of our case that raise the question, and it's either the Casablanca of all the gin joints on all the world, or what I call the human bloodhound, where it's the same officer just keeps, we had this in New Mexico with one guy at a port of entry for truckers. This one officer just kept getting all these drugs, and I referred this one for secondary inspection. Oh, look, there's drugs again. At some point, the totality of the circumstances come into play, and it's easy to discern, I should say, a connection.
The only thing I would add to that is that for intelligence surveillance, there are some documents the government has disclosed that are very, very vague, but they are policies about when the intelligence agencies can share data from certain surveillance authorities with state, local, tribal law enforcement or with other federal agencies. So there is one you can get in unredacted form about 12333, the very large, scary authority that I mentioned. There are also several for Section 702, the Foreign Intelligence Surveillance Act. So again, these are massive U.S. surveillance programs. So you can look to those as evidence that we know the government shares intelligence with state, local, tribal law enforcement because they say they do. They've at least set up the policy apparatus to do that. And so you can point to those documents.
Okay, well, I would like to thank both Sarah St. Vincent from Human Rights Watch and Brian Pori, Assistant Federal Public Defender from New Mexico, for joining us today, for talking us through government evidence laundering. What does it look like? Where does it come from? And how do you challenge it? For those of you who watched who want to refer other people, this will be available as well on our website in the coming days. And thank you for joining us.